Prior to any development taking place, whether it be large or small in the state of New South Wales, it needs to ensure that it complies with the relevant planning controls. These controls ultimately ensure that the development is socially and environmentally sustainable. Two pertinent forms of legislation that govern the Australian property and environmental planning industry are the Environmental Planning and Assessment Act of 1979 and the Heritage Act of 1977. The formation of the EPA Act, specifically Sections 4 and 5, allowed greater public participation in the processes that shape the local community's future. The purpose of the Heritage Act was to provide registration and identification of items that are of local or state heritage significance. Overall, the goal is to conserve and protect items of state or local significance via the function and establishment of the Heritage Council and its associated operations.
The Environmental Planning and Assessment Act of 1979 is legislation that sets out the laws of planning in New South Wales. It's designed to protect the state's natural resources while ensuring landholders have lawful entitlement to use and develop land. In the current iteration, effective the 31st of August 2020, Section 1.3 outlines the objectives of the Act, with relevant objects to this case being the promotion of economic development of land and delivery of affordable housing through development. Additional objects were added in the 2018 amendment in an attempt to promote confidence in the state's planning. A noticeable change is the addition of paragraph F, which promotes the sustainable management of built and cultural heritage. This begins to show the interplay between the EPA Act and the Heritage Act. It should also be noted that while the power given by the Heritage Act to impose interim heritage orders is intended for the protection of key cultural sites, it shouldn't affect the above entitlements of a landholder given under the Environmental Planning and Assessment Act. A key section of the Act in this case is Section 4.1, paragraph 1, which explains the applicant did not need consent for the development. Section 4.1 states that if an environmental planning instrument provides that specific development may be carried out without the need for development consent, a person may carry the development out in accordance with the instrument. The environmental planning instrument for the area is Ryde Local Environmental Plan 2014, which does not list 68 and 17 Chatham Road, Denistone as an item of heritage significance. Section 5.10 of the Ryde Local Environment Plan 2014 looks further into the need for consent, stating in paragraph 2 that development consent is only required for the demolishing of a heritage item, Aboriginal object, or a building, relic or tree within a heritage zone. None of these apply to the development at 6817 Chatham Road. Therefore, according to the Local Environment Planning Instrument, no consent was required. Finally, Section 8.19 outlines compensation concerning development control orders, with paragraph 1 stating that the court has the power to award compensation to a person whom a development control order was given, including any expenses that may have been incurred as a consequence of the order. Due to the court finding the interim heritage order was invalid, it required the respondent to pay the applicant's costs of proceedings.
In Syncept Chatham Pty Limited versus CityofRyde Council, the applicant lodged a DA to demolish two adjacent California bungalows at 68 and 70 Chatham Road, Denistone, in order to make way for redeveloping the site. Whilst considering the DA, the council decided to place an interim heritage order on the houses so as to protect them from demolition. The council had previously identified the area as having local heritage significance, but had declined to list it as a conservation area. Section 25 of the Heritage Act 1977 provides councils with the authority to make IHOs, provided the council considers a preliminary heritage assessment which determines the property to be of local heritage significance. The assessment must be prepared by a person with the appropriate knowledge, skills and experience. In this case, an external consultant was hired by the council to carry out the assessment, a summary of which was provided by a council planner to the mayor with a recommendation from the planner that an IHO be placed on the houses. The applicant challenged the making of the IHO on the basis that the council had failed to properly consider a preliminary heritage assessment as required by the Heritage Act. In its submission to the court, the council provided a copy of the email sent to the mayor as evidence that for all necessary purposes an assessment had been considered by the council. The council also argued that regardless of the assessment process, the Act does not require them to accept the recommendations of the preliminary heritage assessment and that it can choose not to adopt it in whole or in part.
Legislative framework for heritage conservation. The Heritage Act 1977 provided the first systematic means of protecting heritage in NSW. It enabled interim conservation orders and permanent conservation orders. The Environmental Planning and Assessment Act 1979 and the Heritage Act 1977 were originally conceived as a single act. But it was split and the Heritage Act was expedited to deal with urgent issues at the time. So there was always going to be interplay between these two acts since they were originally envisioned as one act. Now let's look at some of the interplay between both the acts. The EPA Act Section 4.44 subsection 2 applies to developments by or on behalf of the Crown that requires approval under Section 57 subsection 1 Heritage Act, which are called integrated developments. However, according to Section 4.46 subsection 4 of the EPA Act, developments are not considered integrated developments if approval is required of a council. Section 57 subsection 1A of the Heritage Act states interim heritage orders by a council covering activities in Section 57 subsection 1, example, demolishing a building, excavating land, damaging trees and vegetation on the land, carrying out development, does not apply to development carried out by or on behalf of the Crown, including persons prescribed under Section 4.32 subsection 2 of the EPA Act.
What happened, and what was the outcome? The court found that the City of Ryde Council invalidly issued an interim heritage order on the landowner's two properties in Denistone. The council failed to provide a preliminary heritage assessment, which rendered the heritage order invalid, as required by paragraph 1A and 1B of the Minister's authority granted to the council. Please refer to the left of the slide. Further, this is pursuant to Section 25, paragraph 1 of the Heritage Act 1977. In this case, the council relied solely on mayoral minutes, with no appendices or attachments as its main source of assessment to the interim heritage order, determining the local heritage significance to be 1920s interwar Californian bungalow dwellings. Due to no professional advice provided by a qualified heritage consultant, the council was found to be in breach and the interim heritage order void. Furthermore, the confidence in the system could have been undermined further if City of Ryde Council were able to impose an invalid interim heritage order and affect the landowner's lawful entitlements under the Environmental Planning and Assessment Act 1979. I believe this case was a classic instance of the council using bullying tactics to exert their power and take away the lawful rights of the landowner. What should have happened? It is clear that there was a lack of transparency on behalf of the council with the landowners of the two properties and the local community. Upon the council discovering the properties held any heritage significance, preparation of an IHO with a supported heritage study by a professional should have been undertaken. Furthermore, an updated planning proposal must be prepared for the two properties in Denistone under the provisions of the Environmental and Planning Act with community consultation prior. Once undertaken, members of the community could agree to the updated planning proposal and as to whether or not the dwellings are to be heritage listed. Please note that upon the outcome of this case, the City of Ryde Council has now listed Chatham Road, Denistone, where these properties are situated, as a heritage conservation area. Court orders. As presented within the case, the failure to complete a professional assessment, which is a subsection of paragraph 1 of the authority, led to the invalidity of the IHO. The council was also ordered to pay the applicant's costs of the proceedings. In future, we must ensure that the council does not manipulate the EPA Act and adheres to the sections required of the Heritage Act.